Hello, I am Elsa Sakir from CQ University. I am making this video as a part of my assignment of Australian Commercial Law. This case is related. This case is about the Barry and the Angelo. Barry, the buyer of the store, and Angelo, the seller of the store. Barry is tired of his daily job and wanted to start his own business, so that he is searching for the business. And Angelo is the seller. He wants to sell his shop, and one day Barry saw the advertisement of the shop, fruit and vegetable shop, and he decided to buy that shop. Barry made few investigation regarding the expenses of the shop and went to check the shop on weekend whether it is busy or not. He found that buying the shop will be beneficial for him, and signed a contract with Angelo without hiring the lawyer to save some money. After acquiring the store, he revealed many problems. He came to know that the statement presented in advertisement regarding the monthly turnover and competitor was wrong, and the actual monthly turnover is less than the stated in advertisement. Further, it stated in advertisement that there is no competitor for the shop, which is not true. He also discovered that the seller also hid that the delivery van was on lease and the loader is also defective. Need for lease payment of delivery van and replacement of loader has increased the expenses of Barry. So now Barry is in trouble. So we need to advise Barry how he can challenge the validity of contract based on the statement made by the Angelo before the contract was entered. The issues that regarding this case is fraudulent misrepresentation, the untruthful statement of fact which pursues a person into a contract. There are three types of misrepresentation. They are fraudulent, negligent, and innocent. Here the statement given by Angelo comes under the fraudulent misrepresentation. Here the Angelo, the seller, has given the false statement about the profit, competitors, expenses, and stock in trade that induce Barry to enter into the contract. After acquiring the shop, Barry realized that all the statements given are wrong. In fact, the profit was less than said one. The expenses is also higher, and there is the competitor also. So here the Barry who entered the contract in reliance on the misrepresentation can recover any consequential damages following from the misrepresentation, and can cancel the contract and return of the parties to the position they would have had if the contract had not been made. And the next issue is misleading contract. Here in the case, the seller Angelo has sold plant and equipment hiding the fact. The delivery van is on the lease. Whenever the goods are sold to the consumer, they come with the statutory guarantee. The statutory guarantee is consisting of title, acceptable quality, fit for purpose, conformity, repairs, and the Section 51, Section 52, Section 53 of Competition and Consumer Act 2010 defines about the title. This includes full title, free of encumbrance, undistributed possession. Here the van bought by Barry should be free of encumbrance, but it is not like that, as it is on lease. On the other hand, the loader sold by the Angelo was also not in the good condition. The Angelo knows this fact, but he hides his fact and sold the loader to the Barry. Here Angelo misled the Barry. S18 of Australian Consumer Law outlined this misleading conduct. Here the Barry can encounter validity of the contract. Further, as Section 236, Barry can get compensation for the financial loss faced by him due to mislead. Here the seller Angelo tried to deceive Barry by fraudulent misrepresentation and misleading conduct. On the other hand, Barry also has some mistake. He took the decision without doing deep investigation. He didn't check the condition of loader while purchasing the loader. This was his mistake. So for solving this problem, I'm going to use IRAC method, that is issue, relevant rule, application, and conclusion. Issue is that whether Angelo has breached the Sale of Goods Act while selling the plant and equipment, whether the advertisement done by Angelo falls under the misrepresentation and false, misleading, or deceptive conduct. And the relevant rule consists of, according to Australian consumer laws, Section 18(1), misrepresentation and false, misleading or deceptive conduct. The advertisement published by the Angelo lies on fraudulent misrepresentation, whereas the good sold by Angelo falls under the Sales of Good Act. The application for this case is related to Australian Consumer Law, the Competition and Consumer Act 2010, and the Sales of Goods Act. In the case, Angelo presented the false statement while advertising for the goods. So this is the case of fraudulent misrepresentation done by Angelo. And another is the sales of good contract. So the remedies for misrepresentation is Berry can sue Angelo for damages or ancillary orders such as rescission or variation of contract, and Berry may apply for an injunction to stop or prevent breaches. And remedies for the Sale of Good Act is discussed to solve the problem of Berry to recover the loss bear by the Berry due to purchase of delivery van and loader. Here the Berry can sue Angelo for breach of contract. The conclusion is that the Angelo is responsible for breach of contract as he has falsely represented the fact to the sale his store. Further, he has violated the Sale of Good Act rule. Here the Berry is innocent, so the case is in the favor of Berry. Therefore, Berry can either terminate and recover losses or enforce the contract and recover losses. Thank you.